Hello, everyone. I am delighted to be part of this workshop. I wish I could be there in person. I want to thank the organizers so much for allowing me to record my remarks and present them here today. And let's just get into it. This subject is very dear to my heart. It's something that I've been sort of an evangelist on for a few decades in the US, trying to teach lawyers that they need to use AI methods, and now as a professor, um, working with archivists and records managers as well, and that they should take a look at AI methods. And that's really what this talk is about. So we will go on here. The Presidential Records Act of 1978 said that in the United States, presidential records are to be transferred to the National Archives at the end of each administration for permanent preservation. Prior to 78, presidents owned their records and they were personal, but now they are records of the American people. There was a lawsuit involving Ollie North's records, the Prof's lawsuit, that in 1989 led to a judicial finding that email records were in fact appropriate for preservation. The electronic versions might have metadata that was worthy of preservation. And so that led to two things. One is that the Clinton White House started an email archiving policy that has had some qualified success over the years. There have been missing emails in the George W. Bush administration and others, but by and large, there's been archiving of email. NARA issued a regulation after the lawsuit, the holding of the lawsuit, saying agencies across the executive branch needed to preserve email records in one form or another, as long as they had the metadata. This has not been as much of a success because there's been a problem with employees printing out email with metadata or dragging and dropping email. And so everyone's been looking for a better solution in terms of archiving. Now, just at the White House, there's been this tremendous growth of email records since the Clinton administration. And you can see hundreds of millions saved. We don't have figures for the latest administration. But here's a key slide, which is that I calculated about a year ago how much of the email, of the 500 million emails that have been preserved by the White House since 1994, has been made accessible to the American people, either through lawsuits or Freedom of Information Act requests. Turns out, not so much, about 500,000. And there are various categories of this. The Supreme Court justice emails is where Congress asks for the emails of individuals who served at a prior time when they were younger in a prior administration before they were nominated. And so senators want to see them. So you add up all of the litigation related and it comes to 0.08%, not very much accessible. And if you extrapolate that to the entire government, that is a real public policy problem. So it will come to pass after 2022 that all of the government's email and all of its other records, hundreds of agencies are going to NARA that is permanent records, going to NARA in digital or electronic form. NARA will not accept paper anymore after 2022. And email was supposed to be managed since 2017, either temporary email or permanent email electronically. So now we have from an era of non-compliance to an era of massive quantities of e-records and email being preserved. And there's a particular policy that I had something to do with, the capstone, that basically said, hey, agencies, you can meet these mandates with respect to email if you just preserve all the email in a particular way. And that way is to say that the records of senior officials at the very top of organizations are permanent, and then email records of everybody else saved for 7 years. But what that means is that those repositories that are separate from any other records are being saved. And by 2030, there'll be billions of emails that are in that 7-year period, and somewhat less, but still a huge amount that are going to the National Archives. And it may not just be email, it could be other forms of electronic communications in terms of electronic messaging. So here you have billions of digital objects that are going to be accumulated over the next decade and beyond, and they're hiding. They're hiding from public access for two reasons. One is because archivists and records managers and lawyers have not really taken advantage of the e-discovery techniques that we know work, the classifiers, the machine learning techniques, based on a whole bunch of studies and cases that I have in the reference slides at the end. These were signal sort of markers along the way where lawyers took advantage of the knowledge and of what information retrieval and computer scientists know. So why can't we apply those classifiers to searching against large public record repositories? And the second reason why records are hiding in plain sight is that various of us need to filter sensitive content from these records. We can't release them just, at large. You need to look and to see whether the sensitivities are there. And FOIA builds in sensitivity. So there's a presumption that all records are open except for 9 exemptions in the US. And those exemptions are ones that you could well imagine. They're national security and PII and health records, criminal history records, proprietary records, and one that I like, which is legal privileges. And in particular, the deliberative process privilege is used by US agencies to block access to the public when a record is either both pre-decisional and deliberative. Their opinions or recommendations, candid conversations. And so if a FOIA is filed in real time and the decision hasn't been met yet, well, you withhold those records. So I was interested in looking to see how well an AI classifier could filter for that particular privilege, not for any of the other ones, but that one. So my colleagues and I built a little sandbox model. We took emails from the Clinton White House from Elena Kagan, who again, wasn't a Supreme Court justice then, she was an advisor on domestic policy to Bill Clinton. And so she created thousands of emails and I looked at them, and what we did is I coded them paragraph by paragraph, what's fact and what's opinion. And then another lawyer coded a subset of them. And we compared and then we looked at classifiers, using a test sample, a training set of what we had coded, and then to see, learning from that, whether they were successful in looking and predicting what paragraphs would be sensitive, deliberative process paragraphs in the rest of the collection. And now I don't have time to go through it. You could read the paper, but the fact is that we have different permutations here of classifiers and custodians and reviewers. And you can see that it's pretty good. The F1 measures based on precision and recall are pretty good, 70, 80%. A little less so when there are 2 attorneys with their own assessments. But the bottom line is that this was a pretty successful exercise. For an attorney coding this and the classifier looking at it, between 70 and 83% F1. And, we talked about in the paper reviewers, different document types, and we made the collection freely available. This is great, but it's a sandbox exercise. And what I want to do next is to have a test collection that's, 1,000 times larger, in the millions. And I'm working on it. So we'll see. But, and to apply these AI filters, not just to deliberative process, but across the exemptions as much as we can. So that's my research agenda for the immediate future. I think the keys to unlocking archives and any kind of record repository is searching using machine learning and filtering using machine learning classifiers for sensitivities. And if archivists and records managers and government officials recognize the value of that, they should put some money in on the front end, which will save money in the review and everything that comes after that. So I have a bunch of references in the paper. I'll make the paper obviously available. I really thank the organizers for inviting me to be part of this workshop. Thanks so much.